Hi, this is Justin Lawrence from Lawrence & Associates, and we're going to talk about the different types of damages that are available to you in a personal injury lawsuit. The first thing you need to remember is that personal injury is car accidents, slips and falls, medical malpractice, defective product cases, and certain types of maritime or admiralty cases. It doesn't include injuries that happen at work. Those types of damages go through the workers' compensation system and have a very different set of rules. But for the other types of cases that I just mentioned, the types of damages boil down to medical bills, lost wages, pain and suffering, and loss of consortium. And it's very rare that you'll find a case that goes outside of those four categories of damages. When you're talking about medical bills are past medical bills and future medical bills. Past medical bills in Kentucky are the full amount that you were billed by the medical provider. In Ohio, however, past medical bills are only the amount that were paid by whoever paid the bill, including your insurance carrier. So in Ohio, medical bills are typically much less than the medical bills that are presented in Kentucky. In both jurisdictions, future medical bills are dependent upon how certain the doctor can be in the records that the future treatment will happen. If the doctor has told you that you will probably need future treatment, but can't pinpoint a specific date or time period, and can't tell you exactly what the treatment will be, then future medicals are speculative and it's unlikely that you'll recover them. However, if the doctor is able to tell you that you'll need a specific treatment at a specific time, then it's likely that you'll be able to recover future medical damages for that treatment. Like medical damages, lost wages can be past lost wages and future lost wages. Past lost wages are usually easy to calculate. Past lost wages include the amount of money you've actually missed out of your paycheck, and also any vacation or sick time that you've taken to flush out your paycheck while you're off work. On the other hand, future lost wages are based on loss of future earning capacity. And that's a complicated subject that's usually an expert's field to figure out. Typically, if loss of future earning capacity is in play in a personal injury lawsuit, either a vocational expert or an economist, or sometimes both, will be employed by the attorney to assist in figuring out what loss of future earning capacity actually is. Finally, you have pain and suffering and loss of consortium. Pain and suffering is physical pain and mental suffering that's associated with the injury. Loss of consortium is the loss of services and household support and affection of a spouse or sometimes of a child. Loss of spousal consortium, loss of parental consortium involving a child or parent, and pain and suffering are very difficult to quantify, and typically juries will give wildly different answers to the same set of facts for what pain and suffering or loss of consortium is actually worth. The last thing to remember about damages is that an attorney helps make damages higher in a case. There have been multiple studies done that showed that an attorney can increase the damages on a case by as much as 50% simply by being involved in the lawsuit. The reason for this is that an insurance company bases its estimate of what the damages are on how likely they are to lose the lawsuit. When an attorney is involved, the insurance company is much more likely to lose because an attorney knows how the court system works and how to conduct a trial. An individual representing themselves doesn't know those rules and therefore is more likely to lose. If you have any other questions about damages, visit us at www.lawrencelaws.com or call one of our attorneys for a free consultation.